Hello everyone, and welcome to the first of our video tutorials on duress. In today's video we're going to be looking at duress by threats, and in a second video we'll be looking at duress by circumstances. Duress is a defence where the defendant has committed the actus reus of the crime and they have the mens rea to commit the crime, but they're raising the excuse that they only committed the offence because they were threatened with death or serious injury if they didn't commit it. Where the defence of duress is successfully pleaded, it absolves the defendant of all criminal liability, so it is a full defence. And the rationale behind the defence is that whilst the defendant clearly has the mens rea of the crime when they committed it, they're acting out of compulsion and are therefore not exercising freedom of choice. And in this respect, the defence of duress differs from most defences which seek to show that the defendant lacked the mens rea, for example, intoxication and insanity. The defence of duress also differs from the defence of self-defence, which perhaps provides a justification for committing a crime. Duress operates to provide an excuse for criminal behaviour. And for that reason, some people describe the defence of duress as a concession to human frailty, that it recognises that people are only human, and if themselves or their loved ones are threatened with death or serious injury, then human nature is that you might well commit that offence. Although the defence of duress is a general defence, there are quite a lot of limits on its application, and in particular we're going to see that the defence of duress cannot be raised in crimes of murder, attempted murder, or anyone that's participating in a killing. Recent case law as well, key case being Hassan, shows that the defence of duress has narrowed in its application, and it's actually much harder to plead now than it used to be. There are two types of duress, duress by threats and duress of circumstances, but today we're going to be focusing on duress by threats. Duress by threats was defined as being available in the case of Whelan when the accused was told to commit an offence and was subject to, quote, threats of immediate death or serious personal violence so great as to overbear the ordinary powers of human resistance. And we're going to have a look at the rules on duress by threats. Established in the case of Graham applies to determine whether a threat is so great as to overbear the ordinary powers of human resistance. The facts in the case of Graham are quite strange, and it involves a bit of a love triangle. Our defendant actually lived with his wife and his homosexual lover, and the homosexual lover was a man called King, and King really wanted to get rid of the wife. She was a bit of a spur wheel, in his opinion, and on one occasion King tried to kill the wife, and the defendant stopped him on that occasion and sustained cuts to his hand. So this was all showing that King was a very violent man. On a second occasion, King convinced the defendant to help him kill the wife, and they strangled her to death with the flex from a coffee percolator. And the issue in this case was that our defendant wanted to plead duress. So he was admitting, yes, he had assisted in the killing, but he was only doing so because he felt threatened by this very violent man, King. Now, in this case, he wouldn't have been able to use the defence of duress anyway, because this was a murder, and we know from the previous slide that you can't plead duress to murder. But nonetheless, this case is important to us because the Court of Appeal created a two-stage test, to see whether the defence of duress should succeed in other cases, obviously not involving murder. And the test is subjective and objective. So it's got a subjective limb and an objective limb. The subjective limb is all about what the defendant themselves felt. So the jury are asked to consider, do they think the defendant acted because he reasonably believed he would face death or serious personal injury if he didn't? And then the objective test is whether a sober person of reasonable firmness and what that means is not quite clear, would a sober person of reasonable firmness with the same characteristics as the defendant have responded in the same way? So this two-stage test is a limit on the defence of duress, but there are other limits as well. So we also need to consider the seriousness of the threat, and the case of Vega is important here. The facts of Vega were that our defendant had been convicted for importing drugs, and he appealed, saying that he'd done so because he was acting out of duress. He'd received threats of serious violence against him and his family if he didn't comply, and there were also threats to reveal his homosexual activities to his wife, and also threats to reveal financial problems as well. And this case established the principle that we've got here, that threats to reveal sensitive information alone are insufficient to raise the defence, but they can be taken into account if they're accompanied by threats of death or serious personal violence. So although our defendant in this case was very concerned about the threats to reveal his homosexuality, if that was the only threat he'd received, that would not be enough. But the court was saying because he had lots of threats or cumulative threats, including death or serious injury, we could take all of it into account. But we need to have a threat of death or serious injury in there. The limit on the defence is what we call nexus, and this means that the threat must be accompanied by an order to commit a specified crime. It's not enough that the defendant has felt the need to commit a crime to meet a demand for money. This is illustrated in Cole, where our defendant borrowed some money from a loan shark. The loan shark threatened him and his girlfriend with serious violence unless he repaid the money. But the loan shark didn't say how he should repay the money. He just said, I'm going to get you unless you repay. Now, our defendant robbed several building societies in order to get the money, and he then tried to raise the defence of duress. But he wasn't allowed the defence because the loan shark never told him to rob the building societies. He'd made that decision himself. So there must be nexus, meaning a sufficient connection between the threat and the crime. So the threatener needs to say what crime it is he wants the defendant to do. Another limit on the defence is that the threat must be unavoidable. Now, this rule has been interpreted in lots of different ways over the years. It started off being very strictly interpreted. Then it sort of loosened and we were more lenient with it for several years. And now we've gone back to the much more strict approach. So in Gill from 1963, our defendant claimed that he and his wife had been threatened unless he stole a lorry. But there was a period of time between the threat and him committing the offence where he'd been left alone. And he could have raised the alarm, he could have potentially called the police. Now, the court said if the defendant has an opportunity to inform the police, the defence of duress will fail. So the threat must be unavoidable. If you could have escaped, if you could have avoided the situation, then that's what the court wants you to do. A more lenient approach was taken to unavoidable threat in the case of Hudson and Taylor. Here we had two teenage girls who were witnesses of a fight which occurred in a pub, and they were called to give evidence in criminal proceedings against one of those involved in the fight. And they'd been threatened with violence if they gave evidence against this defendant. And the threat had been repeated on several occasions leading up to the trial. And on the day of the trial, the person making the threats was in the public gallery in the courtroom, and he was staring menacingly at the girls. So the girls committed perjury, which means lying in court, and then they tried to plead the defence of duress in relation to the perjury that they'd committed. And they were allowed the defence. So the Court of Appeal took quite a lenient, quite a soft approach here. And they said that the defence of duress was allowed because the threat was still operating when the defendants were giving evidence in court because the threatener was glaring at them, and they believed it could be carried out imminently. Now, the prosecution, who wanted to prosecute them for perjury, were saying that they shouldn't be allowed the defence of duress because they were saying it wasn't immediate enough. They're in a courtroom. They could have contacted the usher. They could have passed a note to the judge. They could have got the attention of police. And if you followed Gill strictly, then that would be the case. But as I say, I think the court felt quite sorry for them, and perhaps the fact they were fairly young came into play. But they were saying it was still operating, the threat was still hanging over them. Another case with a sort of lenient interpretation of immediacy of the threat was Abdulhussain. And in this case, our defendants were Shiite Muslims from southern Iraq. Abdulhussain had been sentenced to death in Iraq following a confession which had been extracted by torture. And these other defendants were also fugitives facing death sentences in Iraq. They were living in Sudan and they feared that they were going to be deported by the Sudanese authorities. So they hijacked an aeroplane bound for Jordan and it landed at Stansted Airport. After negotiations for 8 hours, our defendants surrendered and they wanted to plead the defence of duress. And initially, the prosecution was saying that the threat was not immediate enough. But the Court of Appeal quashed their original convictions and said that they should be allowed the defence of duress. And the Court of Appeal said that the threat need not be immediate, but imminent, and that the threat needed to be hanging over them. And there was an interesting quote in this case where one of the judges said, you shouldn't have to wait till the Gestapo are at your door before you take action. So this idea that the threat was very real to them, it was hanging over them, they shouldn't have to wait, and you shouldn't have to wait for duress until you're about to be killed. You should have a bit of time before then. However, we've now got a leading House of Lords case on this, the case of Hassan, and they took a much stricter approach and they actually criticised the case of Hudson and Taylor in it. And in this case, the House of Lords said the threat must be immediate or almost immediate. So they've returned the situation back to Gill, basically. And because Hudson and Taylor and Abdulhussain were Court of Appeal decisions, this was House of Lords, so House of Lords is going to trump them. So now if you've got any time where you could have escaped or got help, the defence of duress is going to fail. Hassan also said that duress is going to be unavailable where the defendant voluntarily associates with known criminals. So if the defendant has joined a violent gang and then the violent gang threatens him to commit a crime, he then can't use the defence of duress. So again, this is very restrictive on the defence. And the final restrictions on the defence we're already aware of. You cannot plead duress to murder. And that comes from a House of Lords decision called Howe. And you are expected to act heroically. So if a terrorist gets in your car with a gun to your head, tells them to drive to college so that they can execute students, and you think you're going to be shot otherwise, so you go and do it, you drive them there, you cannot plead duress. And that's incredibly harsh. In this case, Obiter, they said they didn't think it would be available to attempted murder either. And that obiter was applied in the case of Gotts, where a 16-year-old boy attempted to kill his mum but wasn't successful. And he did that after being threatened by his dad. But the House of Lords again confirmed you can't plead duress to attempted murder either. And the case of Wilson from 2007 adds to Gotts and says that the age of the defendant's irrelevant. So here a 13-year-old boy was really scared of his dad and helped him to kill somebody. And again, he couldn't plead duress. And that does seem very harsh, particularly when you've got a very young defendant. And another harsh aspect of the defence is that they will not take into account a low IQ when deciding would a reasonable man have responded to the threat. So that's the defence of duress by threats. Please watch the next video on duress of circumstances.